Ahaji from AhajiAmos.com. Thanks for joining me. And today we're going to be talking about how you can stop a competitor for using a mark that you either have been using or you want to use in the future. The most common way to stop a trademark from issuing into a full registration that gives them the right to stop you from using it is to file an opposition. An opposition to a trademark can be filed during the opposition period. The opposition period occurs after the U.S. Patent and Trademark Office has allowed the trademark, which means that it's gone through the examination process and the trademark examiner is saying, yes, I believe you are eligible for a trademark. I've done a search. I don't see any conflicting marks and you meet all the legal requirements for a trademark, so I'm going to allow it. After that period, there is a period of opposition. The period of opposition involves publishing the trademark in a publication referred to as the Official Gazette. It used to be a really giant book that is published by the USPTO every Tuesday, and now you can see it online, and it's fully searchable. We have monitoring systems that search it every evening to see if any of our clients' marks are being used or anything similar to our clients' marks are being used. But it's published in the Official Gazette for 30 days. During that 30-day period, anyone at all who believes that they will be harmed in any way by the registration of the trademark can file a notice of trademark requesting that the trademark be withdrawn. That is one option. Another option is to file a cancellation. If you miss that 30-day window, you can then wait until the trademark issues. It takes about 3 to 6 weeks after that opposition period is over, if there are no opposers. You can wait till after, and then you can file a notice of cancellation. The notice of cancellation is almost the same as the notice for opposition, and you're essentially saying the same thing. Hey, I'm here, trademark office, you missed me. For these reasons, it shouldn't have been allowed in the first place. So I'm asking you to cancel the now issued trademark. Those are the two best options. I mean, you can always go to court and make those same arguments. You can sue in federal court if you want. You can sue in state court if you want. But those are a lot more costly and a lot more cumbersome than just asking the trademark office to withdraw or cancel the marks. Now, with the trademark cancellations and oppositions, you are inside the appeals section of the trademark office, and they don't have jurisdiction to make money judgments. So if you're looking for money, then you need to sue in a court of law. If you just want the trademark canceled or you want it withdrawn, then your best bet is to file a notice of opposition or cancellation. Again, notice of opposition needs to happen during that 30-day opposition period in which it's published in the Official Gazette, and cancellations can really happen almost any time thereafter. Grounds for opposition. The grounds for opposition are very broad. You can allege, hey, I did it first, I have priority. Trademark rights come with priority. The first to use has superior rights to all others. So if you used it before in interstate commerce and you used it as a trademark in a trademark way, then you can allege, hey, priority, I get it first. I know they got a registration on it, but hey, I was here and you missed me, so I want that trademark withdrawn because I did it first. You can allege fraud. You can say, hey, they lied. They stole it from me, and so they shouldn't get it, or they lied to the PTO and they shouldn't get it. So that's another way. You can even allege that there's a likelihood of confusion. You can say, hey, well, my trademark's not the same, but it's pretty darn close, and I think that the consumers are likely to be confused. There doesn't even have to be actual confusion. A trademark can be canceled or withdrawn using a notice of opposition or cancellation just because there's a likelihood that the consuming public are going to be confused about the origin of the products listed when they are looking at the registered trademark or the allowed trademark and the opposer or petitioner in the case of a cancellation, when they're looking at those two trademarks side by side. So you can definitely allege that. There is a whole host of reasons to file an opposition or cancellation. I can't go over them now. The video would be too long and you definitely stop watching, so I'll leave it there. But again, if you see a trademark and you think it shouldn't have been issued, you think it is confusingly similar to yours, you think you did it first or you used it first, any reason that you might have to not want that trademark to issue can probably be alleged in a cancellation or an opposition proceeding. And that's my recommendation in cases where you want to stop your competitor or anyone else from getting a trademark. And obviously, my law firm handles oppositions and trademarks. It's becoming a huge part of my practice. It's probably the most fun for me. And so I would love to help you out if you want to file a notice of opposition or a petition for cancellation, or if it's been filed against you. I do both plaintiff and defense work, so either side of an opposition or cancellation, I can definitely help you out. And even if there's a trademark that hasn't been allowed yet and you have some concerns, there are things that we can do while that application is pending to try to prevent it from even being allowed in the first place. So if you need help, please give me a call. I'll put all my information in the information box under the video. And you can also get all of this information on my website. The website address is ahajiamos.com. And you can schedule a free consultation right on the website. Have a great day. Bye.